If you have ever filed your taxes in the United States, whether you used a Social Security number or an individual taxpayer identification number, whether you are a green card holder, a visa holder, or an undocumented immigrant who has been paying taxes faithfully for years, I need you to watch this video all the way through, because what has unfolded over the past 10 months at the IRS is one of the most significant and frankly unprecedented shifts in how the federal government handles your private financial information. There is a lot of confusion and fear circulating right now in our communities, and I want to give you the full picture. What actually happened, where things stand today, what the courts have said, and most importantly, what you should do right now to protect yourself. So let's take this step by step. For decades, and I mean literally for decades, the Internal Revenue Service operated on a foundational principle that made the American tax system function. If you pay your taxes, we protect your information. That promise applied to everyone: citizens, green card holders, visa workers, and yes, even undocumented immigrants who were encouraged by the IRS itself to file their taxes using individual taxpayer identification numbers, commonly known as ITINs. The IRS issued those ITINs, 9-digit numbers for people who don't qualify for a Social Security number, because the government wanted everyone paying into the system to do so safely, without fear of consequences from other agencies. The legal framework protecting all of that is Section 6103 of the Internal Revenue Code, which Congress passed and has strengthened over the decades. It is not a minor rule. It is a federal law that restricts the IRS from sharing your return information with other government agencies, except in very narrow circumstances, primarily involving certain criminal investigations. Even the President of the United States is blocked from directly accessing your IRS data. That is how serious and how long-standing these protections have been. So when I tell you that on April 7, 2025, the Internal Revenue Service and Immigration and Customs Enforcement signed a formal Memorandum of Understanding, an MOU, to create a framework for sharing immigrant taxpayer data, I want you to understand why that shook the immigration and tax communities to their core. As ProPublica reported in detail, the push to share IRS data with the Department of Homeland Security emerged while the Trump administration's DOGE team was reshaping the engineering staff of the IRS. According to ProPublica's reporting, a Silicon Valley startup founder with no prior government experience pushed out more than 50 IRS engineers and restructured the agency's engineering priorities while serving as the senior DOGE official at the agency. Multiple senior IRS officials, including the then-acting IRS Commissioner Melanie Krause and the IRS Acting General Counsel Andrew DeMello, refused to comply or resigned in protest. Their departures were widely reported by the New York Times, ProPublica, and NPR, among others. Now, let me explain what the MOU actually said, because it is important to understand what the agreement claimed to allow, and what the administration actually tried to do with it. The Memorandum of Understanding stated that ICE could submit names and addresses of immigrants with final orders of removal, or who were under federal criminal investigation, to the IRS. The IRS would then cross-reference those names against its own tax records and, if it found a match, provide ICE with address information from that person's tax filings. Treasury Secretary Scott Bessent and Homeland Security Secretary Kristi Noem signed the agreement. On its face, the administration framed this as a narrow tool for locating people who had already been ordered deported by a federal immigration judge. But here is where the reality diverged sharply from that framing. In August of 2025, ICE submitted a data request to the IRS for the records of approximately 1.28 million taxpayers. Not a few hundred, not a few thousand, 1.28 million people. As reported in court filings and confirmed by IRS Chief Risk and Control Officer Dottie Romo in a sworn declaration, the IRS was only able to verify approximately 47,000 of those 1.28 million names against its own records. And then, and this is the part that the IRS itself has described as an error, for a subset of those 47,000 individuals, the IRS provided ICE with additional address information that went beyond what the MOU authorized. The data was stored on the government-issued computer of a single DHS employee. The IRS discovered this mistake, informed Treasury, and Treasury notified DHS in January of 2026, requesting that DHS help remediate the problem consistent with federal law. Think about what that means in plain terms. Someone at the IRS shared private home addresses of tens of thousands of immigrant taxpayers with an immigration enforcement agency in a way that the IRS's own leadership later acknowledged violated the rules. And ProPublica reported separately that the IRS was simultaneously building a computer system that would give ICE what it called on-demand access to confidential taxpayer data, home addresses, names, family information, on an automated basis. An IRS engineer who reviewed the blueprint told ProPublica that if implemented in its current form, it was extremely likely that incorrect addresses would be given to DHS and individuals would be wrongly targeted. Now let me tell you what has happened in the courts, because this is where the story takes a critical turn that you absolutely need to know about. Two separate federal judges have now stepped in to block this program. The first ruling came in November of 2025, when Judge Colleen Kohler-Catelli of the U.S. District Court for the District of Columbia ruled that the data sharing agreement violated federal privacy laws and put immigrants at risk of their information being impermissibly used by ICE. The Department of Justice appealed that ruling, and the case was moving through the U.S. Court of Appeals for the D.C. Circuit at the time of this video. The second ruling came on February 5, 2026, and it directly addressed what happened with that improper disclosure. U.S. District Judge Indira Talwani in Massachusetts issued a preliminary injunction. And I want to be precise with you about what that means. A preliminary injunction is not a final verdict. It is a court order issued early in a legal case when a judge determines two things. First, that the plaintiffs are likely to succeed on the merits of their argument, and second, that allowing the challenged action to continue while the case plays out would cause harm that would be very difficult to undo later. Judge Talwani found both. Her order specifically bars DHS Secretary Kristi Noem, ICE agents, and any ICE official from inspecting, viewing, using, copying, distributing, relying on, or otherwise acting upon any taxpayer return information that came from the IRS under the Memorandum of Understanding. She also specifically bound the single DHS employee who had that data on their government computer. In her written opinion, Judge Talwani stated that implementing data sharing agreements of this kind erodes the foundation of taxpayer trust and undermines the public interest in a functioning tax system. As of the date of this video, ICE and DHS have both stated publicly that they have not used the shared data for enforcement actions and that they will not use it while the court injunctions remain in place. That is meaningful, and I want to give that statement its proper weight. But I also want to be honest with you. The legal battle is ongoing. The injunctions are preliminary, not permanent. The administration has appealed, and the outcomes of those appeals will shape what happens next. This is a situation that could change, and I will be here to keep you updated as it does. So let's talk about what this all means for you personally, because that is ultimately why you are watching this video. And I want to speak to different people in our audience because your situation may be very different depending on your immigration status and how you file your taxes. If you are a lawful permanent resident, a green card holder, or if you are in valid visa status such as H-1B, L-1, O-1, or F-1, let me be direct. Your tax filing obligations have not changed. You still need to file. Your residency status for tax purposes, which is determined by whether you meet the substantial presence test under IRS Publication 519, still controls what form you file and what income you report. Many H-1B and L-1 workers file as U.S. tax residents on Form 1040. Many F-1 and J-1 students file on Form 1040-NR during their period of exemption from the substantial presence test. These obligations remain fully in effect. The court injunctions block ICE from using your data. They do not remove your legal obligation to file accurately and on time. If you are an ITIN filer, meaning you file your taxes with an individual taxpayer identification number because you do not have a social security number, I want to speak to you very carefully because I know this community is feeling the most anxiety right now. Community tax clinics and legal aid organizations across the country, as reported by KQED and NPR, are still seeing ITIN holders come in to file this tax season. And the experts running those clinics are giving consistent advice. Your filing obligation exists, and the consequences of not filing can be serious. Failure to file and failure to pay penalties apply regardless of whether enforcement action occurs or not. Tax returns are also often required as proof of income for housing, education assistance, and federal loan programs like FAFSA. And as the George W. Bush Presidential Center's immigration policy team noted, historical legalization programs in the United States have typically required proof of tax compliance. So if a future pathway to legal status ever opens up, your tax record matters. I also want to address something that legal experts have raised, and that I think is critically important. The IRS database is not an immigration database. It was not designed to identify people's immigration status. It was designed to track tax compliance. What that means in practice is that IRS records can be messy. Data mismatches happen. Addresses become outdated. Names are entered differently across different records. Multiple IRS engineers who spoke with ProPublica on background warned that any automated system linking IRS data to ICE enforcement would inevitably produce wrong results, wrong addresses delivered to enforcement agents, wrong people targeted. That is not a hypothetical. It is a structural reality of how this data was built and maintained, and it is one of the reasons the courts have found the data sharing arrangement so legally problematic. Let me also address a separate but related development that affects ITIN filers specifically. As reported by KQED, Congress passed the massive spending and tax legislation known as the One Big Beautiful Bill last summer. One provision of that legislation significantly limited the tax credits that ITIN holders qualify for. Beginning with tax year 2025, meaning returns filed in 2026, if a household does not have at least one taxpayer filing with a Social Security number, that family will no longer qualify for the federal child tax credit or the earned income tax credit. Children claimed as dependents will also need a Social Security number to receive the child tax credit. This is a separate policy from the IRS ICE data sharing issue, but it directly affects mixed status families, and it is something every ITIN filer needs to understand before they file this season. Now let me give you the concrete steps I want you to walk away with from this video, because knowledge is only valuable if it leads to action. The first thing I want you to do is go to irs.gov and look up IRS Publication 519. It is the official IRS guide on U.S. Tax Guide for Aliens, and it explains exactly what your filing obligations are based on your status. The second thing is to make sure your tax records are accurate and consistent. Your name, your address, and your ITIN or Social Security number should match across all of your filings. If you have moved and not updated your address, take note of that. The third thing is to save copies of everything: your past returns, your W-2s and 1099s, proof of address changes, any correspondence with the IRS. If a data mismatch ever causes a problem, documentation is your first line of defense. The fourth thing, and this is especially for ITIN filers and mixed status families, is to connect with a qualified tax preparer or a nonprofit tax clinic before you file this year. Many community organizations provide free or low-cost tax help and can walk you through the current rules and protections. And the fifth thing is to consult an immigration attorney if you have specific concerns about how your tax records might intersect with your immigration situation. This is not a moment for guesswork or relying on social media rumors. An attorney who knows your specific case is the right person to guide you. I also want to warn you about something that tends to happen after high-profile moments like this one. Scammers. As courts issue rulings and news coverage intensifies, people posing as IRS or DHS officials will call members of our community claiming they have access to their tax records, threatening deportation or arrest unless they pay immediately. The real IRS does not call you unannounced to demand payment. The real IRS does not threaten immediate deportation. If you receive a call like that, hang up and report it to the IRS at irs.gov. These scams target vulnerable communities, and I want you to be protected from them. Let me close with the bigger picture, because I think it matters for how we process all of this together. What has happened with the IRS and ICE is genuinely unprecedented in the history of the American tax system. As the Tax Policy Center noted, undocumented immigrants pay approximately $60 billion in federal income and payroll taxes every year, and an additional $37 billion in state and local taxes, while being excluded from most government benefits, including Social Security and Medicare. The voluntary compliance rate that makes the entire U.S. tax system function sits at about 85%. Economists have calculated that even a 1 percentage point drop in that compliance rate would cost the federal government $40 billion in revenue. The courts have recognized this. Judges Kohler-Catelli and Talwani both explicitly acknowledged that the credibility and functionality of the IRS as an institution depends on taxpayers trusting that their information will be protected. That is not a partisan statement. It is an institutional one, and it is why this legal battle matters far beyond the immigration community. As always, I want to be completely transparent. Everything I have shared in this video is accurate as of February 17, 2026, verified against court filings, reporting from ProPublica, Bloomberg Tax, PBS NewsHour, The Washington Post, FedScoop, and KQED, as well as official guidance from the IRS at irs.gov and the Tax Policy Center's analysis. This situation is actively in litigation and can change. The content of this video is for informational purposes only. It is not legal advice and cannot substitute for the guidance of a qualified immigration attorney or tax professional who knows the details of your specific situation. Always verify with official sources, IRS.gov, DHS.gov, and USCIS.gov, and please consult a professional for anything affecting your personal case. If this video gave you clarity in a moment when there is a lot of noise and confusion out there, please give it a like. It genuinely helps this channel reach more people who need this information right now. Share it with someone in your family, your workplace, or your community who files taxes and is worried about what these headlines mean for them. And if you are not already subscribed to Immigration News Today, this is the moment. We publish daily updates on immigration law, IRS policy, enforcement developments, and practical guidance for immigrants across every status and every background. Hit that subscribe button and the notification bell so you never miss a critical update. Official IRS resources, court documents, and guidance on finding free tax help are in the description below. We are watching this situation every single day, and we will be back with updates as soon as something changes. Take care of yourselves, stay informed, and we will see you in the next video.